Thank you.
Thank you for being here. Clean water is important to everyone. 80% of small business owners, a clear majority, favor the rules, clarifications, and wetlands protections set forth in the Clean Water Rule. The EPA and Army Corps of Engineers have spent years engaging in a transparent rulemaking process. The agencies have met with stakeholders, small businesses, received over 1 million comments, held over 400 outreach meetings, used important time and resources, and above all, important taxpayer dollars, and are now just weeks away from producing a final clean water rule that will protect our nation's vulnerable waterways and drinking water for 117 million Americans. But what you're saying is the agency should put the brakes on the implementation of this economically critical and scientifically rigorous rule before the public has even had a chance to see the finished product. A decision like that would disrupt and prolong the rulemaking and forces the agencies to go back and solicit input from stakeholders they have already consulted, consider factors they have already considered, and then propose the rule all over again. Has your office considered the impact on small businesses of delaying the rulemaking and prolonging the uncertainty for small businesses about what will be regulated under the Clean Water Act?
Yes, Senator, those are concerns of our office. The main concern that we have is compliance with the Regulatory Flexibility Act. Every rule that EPA produces has to comply with the RFA, and in this instance, they did not comply with the RFA. And so our job at advocacy is to speak for small businesses in that instance.
Well, in the Environment and Public Works Committee, we heard testimony from the new Belgium brewery on behalf of the businesses around the country that rely on clean water for the success of their business. How does the Office of Advocacy take the needs of those companies into effect?
Senator, we take the needs of every small business that we possibly can into account. Again, our statutory obligation is to get federal agencies to comply with the Regulatory Flexibility Act. And in this instance, EPA should have convened a SBREFA panel.
Well, the EPA has estimated that waste from mountaintop removal coal mining has buried between 1,200 and 2,000 miles of Appalachian streams. This mining practice has harmed communities, been linked to contamination of water supplies, endangered wildlife, and threatened public health, all so that much of the coal produced from the Appalachian region can be exported to other countries in the world to increase profits for the coal companies. By opposing the Clean Water Rule, coal companies are continuing their assault on the administration's actions to protect the public health and the environment from mountaintop removal mining. Fossil fuel companies have also threatened legal challenges to the rule before it has even been issued. Will you please tell the committee the groups and associations that your office met with, or which groups encouraged the Office of Advocacy to submit your comments about the Clean Water Rule?
Senator, we met with small businesses in every industry that we could find. They all said that there were going to be costs to this rule.
Will you submit to the committee the companies that you met with, just so that we can have an understanding of who it was that was seeking to lobby you on this issue?
We'd be happy to do that.
Okay, that'd be very helpful. A delay in the Clean Water Rule would provide confusion, not clarify, for small businesses, and add to the delay of important infrastructure projects, and will create jobs and grow our economy. What would you say to an unemployed iron worker, laborer, or American driver that just crossed a near-crumbling bridge or pothole about the delay in the final Clean Water Rule?
Senator, the point of the Regulatory Flexibility Act is to create an environment for small businesses to thrive and grow and provide more jobs. ultimately. And our job is to ensure that the federal agencies comply with the requirements of the statute.
How many public meetings should an agency have to hold on a proposed rule, in your opinion?
Senator, I would say that probably varies with the impact of the rule, but in this instance, EPA should have convened a SBREFA panel.
Is 400 outreach meetings insufficient to solicit input on a proposed rule?
Senator, in none of those outreach meetings, to my knowledge, did EPA present regulatory alternatives or preferred option. In none of them did they present the data on which they were basing the rule.
And finally, are you aware that OMB reviewed the proposed rule and made the determination that the proposed rule would not have significant impact on small businesses? Are you aware of that?
Senator, it is our statutory obligation to speak on behalf of small businesses when it comes to issues under the Regulatory Flexibility Act. In our opinion, EPA should have convened a SBREFA panel because this rule will have impacts.
I think that we should let the EPA do its job. I think delaying the clean water rules makes no sense. Small business owners need clarity, not confusion. That's what your recommendations are going to create, and we're just going to repeat the same process and I think come to the same conclusions. Thank you, Mr. Chairman.